Hi, good afternoon, folks. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community telephone call every other Thursday. So as usual, I'll go over the questions that have been posted. Um, the questions that I have marked as frequently asked questions, I will be taking questions following that right away. Otherwise, I will wait till the end of my call to invite questions on posted issues. Once all the posted issues have been dealt with, then we'll start with new questions. First question that has been posted is Zap Zero Paz, who became a green card holder in 2009. And 3 months later, after becoming a green card holder, was absent from the US for 9 months. Then, second visit, he was in USA for 7 months, and then again absent for 11 months. During the second absence, he continued to pay rent for half of the duration until the lease ended. Also got admitted to a master's program, which he started immediately after coming back for the third time. There was no re-entry permit applied for, no taxes filed for, and because they had not earned any income, no tax returns need to be filed. So the question is, with the lease and the admission, is it strong enough to support that I never intended to leave the United States? What are we talking about here? We're talking about abandonment of permanent residence. Once you get a green card, it's not something that's cast in stone. If you have a green card, you still have to have your permanent home in the United States. And the answer to your question, is this enough, is very difficult to really respond to. Okay. I don't know. It depends upon the CBP, the Customs and Border Protection. They may or may not make an issue of it. The correct criterion is not that you never intended to leave the US. The correct criterion for abandonment is this. When you left the United States, you had a relatively short duration in mind during which you'll be absent. If you leave for indefinite duration or if you leave for a long duration, if you go for a year, you lose your green card automatically. Okay. So bottom line, I do not know if this will be enough. But the good news is, if you do land at a US airport with your green card, they will let you in. If they want to lift the green card, they will lift the green card and have you go before an immigration judge eventually. But you'll be allowed to come into the United States. So I don't know if this is going to be an issue or not, but you have no choice to come back as quickly as you can. Okay. Let's go on to the next question from P1S. I'm a full-time employee of a tech company with HQ in the US. Employers sent them to a client who's also a US company in another state. Then they filed H-1B in April. So I'm assuming you were on OPT. You moved to HQ after the client work was complete, and then we received an RFE. Sent a reply, USCIS has not responded. Okay, the RFE reply was received in the first week of August. 60 days passed, asked for an update. What do I do? I was on F1 OPT STEM. Well, typically, when you have such a long gap between the application and the decision, I suspect it's some kind of a problem either with your paperwork or with the employer. Which one it is, I cannot comment because I don't know the case, nor do I know the employer. You can follow it up with the congressman's office, or you can open a case with the US Ombudsman. O, M as in Mary, B as in boy, U, D as in doctor, Ombud, S as in Sam, M-A-N as in man, Ombudsman. So you can open an online case if you just Google USCIS or Bing or whatever your search engine is. Type in USCIS Ombudsman, and you can open a case with them and see what's going on. Satish Thackeray has an issue with petty larceny, but there was no conviction. Oh no, you have been convicted. Okay, you came as a student, and for petty larceny, there was a conviction. Okay, first of all, if it's a Virginia misdemeanor, which is what you say, if it's only one misdemeanor, and the actual sentence imposed is not 6 months or more, you have no problem. You can Google, or again, whatever your search engine is, the phrase petty as in small, P-E-T-T-Y, petty offense exception. Misdemeanor, a single misdemeanor where the sentence imposed is less than 6 months is forgiven. There's no problem. So don't worry about being kicked out. I would still want you to consult a lawyer, make sure your paperwork is reviewed. Or if you already have a lawyer who's helping you with the green card, let them take a look at your paperwork. I don't think you're going to have a problem. Okay? So don't worry too much. It looks to me it should be straightforward. Rama wants to know, got green card in employment, they basically want to file N-470. Okay? You cannot preserve your residency for naturalization, unfortunately, unless after getting your green card, there is at least a 1-year period, a 12-month period, during which you have not gone outside USA for even 1 day. And in addition, if you are going after getting a green card, you are relocating abroad for personal purposes, not through qualified employment, you cannot file N-470. So there are two requirements. One is that you are working for a US-based company, or the others like you're working as a missionary. There are different kinds of requirements from employment perspective, but it cannot be for personal reasons. And second, there must be a 12-month period during which you have not been absent from the United States even for 1 day. For preserving the green card, I just talked about you've got to file re-entry permit. You are planning to do that, so you should be fine once you do that. With the re-entry permit, can you still preserve your stay for naturalization purposes? Really not. You see, the naturalization requirements are as follows. You must have, in the 5 years before you file the application for naturalization, physical presence in the United States for at least 2.5 years. Okay? Then none of your visits abroad should have been a year or longer. If they are less than a year, more than 6 months, they can ask you to explain. They want to make sure that you did not abandon your permanent residence. Okay? So it's not going to be easy. It's something you should plan carefully, talk with a lawyer, discuss your circumstances. It still may not be able to accommodate, it may not be possible to accommodate your interest, but at least you can talk with somebody and see if there is any way you can get this done. Okay? Hari wants to know, EB3 I-140, priority date of 2011, approved by previous company. It started with them in India, joined, and then transferred to USA on L1. The role was software engineer. He's got a US equivalent of a bachelor's degree and more than 5 years experience. Now he's moved to a different company as a project manager. Now he's got 9 years of experience. Can we do a green card in EB2 category? Certainly, it looks like it. I don't see any problem. Second, because you qualify under BS plus 5. Second is, being on H1B, is it legal to invest in stocks? I don't see any problem with that. The only risk is if you become a day trader, although there's no law on this, I feel government could take an exception to day trading as being almost like a job. But if you have long-term investments, even if you churn them every 6 months or 8 months, I don't see any problem with that. Okay. Next question is from Vijay. I lost my Indian passport in Toronto, then got a B2 visa stamping done again. But every time he enters USA, he gets problems at the CBP because they've got the wrong passport number. What you should do is, Vijay, type in a search engine the phrase, and I did this, I tested it before I got on the phone. Type in DHS, Department of Homeland Security, space TRIP, TRIP, as in taking a trip. There's a program called TRIP where you can get your record corrected and therefore make it easier for you to come the next time. So correct your record through TRIP at the DHS. It can be done online. But if they still ask you to come in and talk with a CBP officer, there's no harm in doing that. Next question is from Jeannie. Currently on H4, which is expiring in 2014, November 30th, in a few days, 10 days. Going to India in December, do I need to wait for the approval of the H4 extension? No, you do not. H4 is given on the basis of the H1, even if you do not have an approval from USCIS. Do you qualify for the Dropbox interview waiver exception? I have to look at the program. Have your lawyers take a look at it? I don't know what the criteria are off the top of my head, but if you meet the criteria, sure, go for it. Okay. The only suspicion I have is that I don't have H4 visa stamp on my passport, as I have entered into the country. If I remember correctly, typically these visa waiver programs require that you have that visa on your passport. So I don't know if you would qualify, but I can't comment. I haven't looked at the program. They keep changing these programs from time to time. Binu 2306 says, came to USA on a student visa, got a master's degree, visa extended till 2015, got a job in Citibank. They were not going to do my H1, so I changed my employer. And I have two REF, I guess you mean RFE, and then they approved H1. So you've got an H1 since October 1st, 2014. Now going for a court marriage with a US citizen and preparing to file a green card. Does that affect my H1 if I get court marriage? Not at all. No problem at all. How long will it take for the green card? Less than a year usually. 6 months to a year. How can I still travel on my H1 visa? You can. If you have a visa stamp, having filed a green card does not stop you. But if you file a 485, I would rather have you wait for the advanced parole. There is some gray area. If you had an employment-based green card, no problem. You can travel on H1 visa. There is a gray area here with family-based green card. So wait for the advanced parole. Make sure you apply for the advanced parole when you file your green card. Then you can travel on the advanced parole. You get it usually within 3-4 months. Okay. And you don't need to get your visa stamped that way. Next question is from Sarabjit. Sarabjit Singh says, I got my I-140 approved under EB2, getting the documents together for I-485. Marriage was not registered in India. The only document we have is a certificate from the temple. You know, Sarabjit, I don't think that's the problem. If you got married in a Gurdwara, in a Sikh temple, or if you got married under the Hindu Marriages Act, neither one of them requires registration. So you can get affidavits from a couple of people who attended the marriage along with a certificate from the temple, and you should be fine. That's not a big problem. Danielle de Leon is a DV lottery winner, LPR since 2014. Left USA almost 9 months ago. Am I going to have a problem coming back? Come back as quickly as you can. You can have a problem, but like I mentioned earlier to another gentleman, if you have a green card, they have to let you in. Then you can, if they want to take away your green card, you can fight it out with them in the immigration court. You'll have to prove that you did not mean to abandon your permanent residence. But come back as quickly as you can. If it's 12 months, your green card will be gone. TM says, graduated in 2013, couldn't find a job, had to get into another degree program to be in F1. I see President's intention. By the way, I hope you guys all know And if you don't, I very strongly recommend you download our apps. We have an app for um, Google platform, no, not the Google, what do they call it? Android platform. And another for the iOS, the Apple platform. Um, and I do send out messages right away, like if something comes up, you will get a pop-up from me on those apps right away. You can also do a follow-up on our just go to immigration.com, our website. On the top right-hand side, you'll see the link to the apps. And on the right-hand side panel, you'll see my Twitter account, which is being streamed or being through RSS is being fed into our website. Subscribe to those. Tonight at 8 p.m., the president is going to address the nation. And let's see what kind of changes are being made in US immigration programs for undocumented as well as legal people. So I'm keeping my fingers crossed. I would love to know more about it. My plan is to start tweeting and start sending out information on the apps as soon as the president stops talking, or even when he's talking, so that I can give you some idea about what they are thinking. Okay. So he says president wants to help people. How about people who are on F1 and F2 have children born in USA? Do they have any opportunity to get a work permit? I doubt it very much. I don't think that's what this plan intends. Unfortunately, for the legal people, it might not work that way. In some ways, it's unfair that the undocumented people have a bigger advantage than documented people, but that's just the way it is. Okay? I doubt it. Immigration Help 2014 wants to know, wife was an LPR, lawful permanent resident, green card holder. She's now become a US citizen. I-130 already approved, and now we are planning to upgrade it to immediate relative. Is it necessary or recommended for my wife to accompany me for a changed IR1 interview? No, it shouldn't be. It shouldn't be. That's not a problem at all. I've been on USA for 6.5 years, F1 then H1B. No relevance. Can she travel to India in the next 2-3 months, or is there an issue of domicile? As long as she is domiciled in USA and the visit to India is temporary, it's fine. But she must be domiciled in in USA for a couple of reasons, for the I-864 as well as for the I-130. So make sure that she does not abandon her domicile. Can she apply for passport in expedited processing? Yes. Look at the requirements on the passport office's website, US passport office's website. I think they do require a return ticket or travel itinerary. Not a return ticket, travel itinerary. In the I-130, there is no mention of which consulate, but there is a column in the I-130 where you have to mention whom you want to be notified. You can actually even correspond with NVC. NVC is good about writing back on emails. So if your wife has any issues, she can contact them. Lokesh, whose handle is Mountain Hope, has an EB3 and I-140 has been approved. Son is going to be 21 on December 21st. See, the problem is, from what I remember, I looked into this issue a while ago. First of all, for CSPA, Child Status Protection, the only time you can take out of his age is the time your I-140 was pending. And typically that's no more than 5-6 months. Okay. Now, let's say you got CSPA protection. If you convert from EB3 to EB2, does the CSPA protection carry over? In other words, can you still deduct the I-140 from the previous pendency? I don't think so. I don't think it works like that. I would have to look at the law in greater detail, but from what I remember, there is nothing that can, this is not going to help your son. It will help you, but it won't help your son. Labor approved. I-140 was pending July through January, so about 7-8 months. So that means he's protected from December to about June, July, 7-8 months. But if you convert to EB2, I don't think that's going to happen. I don't see how. If the priority date becomes current before July 2015, definitely, then we are fine. Okay, and if president does what we think he's going to do with the legal immigration, um, there might be some hope. Who knows? H1B underscore masters is Pratt. He's on H1B, arrested for driving with suspended license, but there was no conviction. So if there's no conviction, there is no problem at all. Oh, I'm sorry, Pratt. I think I may have misunderstood an earlier question. You are the guy who's been having problems with trips. Oh, no, both of you have the same problem. There was an earlier guy who had a different passport and visa. He was having travel problems. Every time he entered, he was detained. You do the same thing. You go through, do a search for DHS space trip, as in travel, and go online on the trip program of DHS and enter your information and tell them to clarify your record. Okay. So if you do that, that should take care of it. Expungement is not the right thing to do. If you have, even if you're not convicted and they are kind of holding you up, just go to the TRIP program and get your record corrected. Now this one is I have marked it as a FAQ. On this one, on the issue of cross-chargeability, I'll take questions right now. No other issue, only cross-chargeability. So here is the situation. First of all, you guys know what cross-chargeability is. Let me explain to you. Normally, when we do an analysis of which country quota you belong to for your employment-based green card, we go by your country of birth. So if you were born in India and you are a citizen of Japan, you are still going to be charged to India, not Japan. If, however, your spouse is born in a third country, so you are born in India, but your wife is born in Japan, you can be charged to Japan. That's called cross-chargeability. And that's a very useful thing to have, because all of a sudden, from a heavily backed up country, you go to a country where the dates are current. Okay. So the problem is she was born in Nepal and he doesn't have a birth certificate. Before I go to that birth certificate issue, let's take the question one by one. First is, does USCIS have discretion to deny such cases? Or do they have to give me the cross-chargeability? And the answer is they have to give it to you. This is not a question of discretion. They are not doing you any favors. Once you meet the requirements, spouse born in a third country, and you can prove it, you are entitled to your cross-chargeability. Okay? You cannot be denied your 485 for this reason. Now, she does not have her birth certificate from Nepal. Is the birth certificate the only way to prove location of birth? It gets tricky. In normal circumstances, if you don't have a birth certificate, what you will do is you will get a certificate of non-availability from the municipal corporation or the village panchayat, village administration where she was born, saying that her birth was never recorded. There's no record of her birth. Then you'll get two affidavits from people like her parents who will say that we know she was born on this date at this place. In areas of cross-chargeability, USCIS may require further evidence, and it can be anything, including some evidence of her having lived in Nepal, things like that. I'm not sure what they could ask for, but it could get a little trickier. Okay. But if you try to register a birth now, that's not going to happen. So if you do go through cross-chargeability and your dates are current, typically you should be approved within a year. Your green card should be done. Okay, now I'm going to answer follow-up questions only on cross-chargeability. If you have a follow-up question on cross-chargeability, press *5 on your telephone. Only on cross-chargeability. No other questions. *5 if you have a question on cross-chargeability. Press *5. Okay, no questions. Let me go on to Another frequently asked questions. This is unpaid leave on H1. I'm asked this question quite a number of times. That's why I have marked it as a fact. I want to clarify a couple of things. If you're on H1, sometimes people ask me, I want to maintain status even though I'm getting laid off. Can I be on unpaid leave and does that maintain my status? The answer is no. Unpaid leave is not a device to maintain status. However, in the case of Instu, which is the posted case, he's gone to India and got the stamping done. He's got paid vacation of 2 weeks, but he wants a few more weeks of unpaid leave. Is this legal? And the answer is yes, it is. When an employer gives you leave, unscheduled, normally unpaid, based upon your request, not because you don't have a project, then for them not to pay you is no problem. And for them not to pay you, especially when you're outside USA, is absolutely no issue. Okay. The only problem is make sure for the green card purposes, the employer is generating enough money to meet the ability to pay wages issue. This is something you have to talk to your lawyers about. Just tell them, make sure if I'm unpaid for a few weeks, it does not affect my green card ability to pay wages issue. Okay. H1 is no problem. If W2 is less than the LCA because you were outside USA, there's a good explanation. What documentation can you show? The fact that you were outside USA. So your boarding passes or any other evidence of you having been outside USA, there should be some email from you or something in writing requesting that unpaid leave of absence for personal reasons, and that should cover it. Okay, so let me address this issue of unpaid leave on H1. Does anybody have a follow-up question on unpaid leave on H1? If so, press *5 on your telephone. Just for the issue of unpaid leave, nothing else. Okay, nothing on this. Again, I have another question I've marked as a frequently asked question. This is on visa stamping. So H1 visa stamping, I have mentioned earlier, is a sticky issue always because you never know what the consulates are going to do. Sometimes they can hold you up for months. So I tell people, if you can avoid going for stamping, do so. If you must go, remember one thing. If you are working in an area that can be considered to be an area that has some implications as weapons of mass destruction or some martial capabilities such as bacterial warfare, biological warfare, they can hold you off there, and they do that very often with researchers. They do some additional checks called visa donkey, visa mantis checks. If you are working at an end client rather than in-house, it's problematic. So here are the questions specifically. I've covered this issue before in a couple of other videos, but let's go on further to refine this issue. Is it possible to get a visa stamping on the basis of vendor letter, or is end client letter a must? Well, they do require end client letter. You have contracts and work orders that cover the areas they want to see covered. What are the areas they want to see covered? Who has control? Who has the right to control? What your job description is? How long is the project? These are some of the things they want to see in the end client letter. If you have that in your job order, did I say job order? I mean work order, or statement of work, something like that. Something that shows, something that comes from the end client and shows what the work is and covers these areas. You may not need a letter. Okay. In what all scenarios visa stamping is rejected from India? I can write a book on that. Too many ways it can be rejected. Most common, insufficient documentation. You can't get something from the end client. Can I come back on H4? Yes, you can. So her husband is on H1. Can she come back on H4? Yes, definitely. You can come back on H4 if the H1 is rejected. That does not mean your H4 is also rejected. How can I work again with my vendor? Will I have to apply H1B again? Yes, you will have to. Is it cap exempt? Yes, it is. I have also applied for I-140 green card. What if visa is rejected and I come back on H4? The green card can go on as long as your employer has the ability to pay your wages. The fact that you are temporarily not employed with them does not stop your green card, as long as they have the expectation and the intention to employ you once you get your green card. Okay, anybody has a follow-up question on H1 visa stamping, press *5 on your phone. Follow-up question only on H1 visa stamping, *5. Okay. In this case, there were multiple applications H1B filed by two different companies for the same individual. That's not allowed. So now they want to revoke, USCIS wants to revoke this. There's not much I can tell you unless you have a very good reason. I mean, same job description, everything is the same. You're not going to be able to get this easily resisted. I think you're going to lose this case. I certainly cannot give you any advice to drastically improve your chances. Same street, the companies are different suite numbers, same president. It's a very tough case. I don't think it's an easy case to win. But can you change employers? No matter what you do, once they revoke, then you're not going to be able to be quota exempt. So you have to look for the alternatives. If you're, can you reopen the case? That I don't think is going to help you. You took a promotion with the company, that's going on from software engineer to senior software engineer. Does that make any difference? No, you still have a problem. Your employer filed more than one application for you, and that's forbidden. Okay, coming back to the last two questions. Tom says, Tom 16, I am on H1B visa. In-laws have visitor visa. I know they cannot stay more than 6 months. Can they come back after 5 months after having stayed here for 6 months? The answer is probably not. If CBP finds out that they are spending more time in USA than in their own home country, they can refuse them entry. And if they want to be really mean about it, they can actually bar them from coming back for 5 years. Okay, so be careful with that. Last question for the day is Crazy Bin. So the question is, for my PERM green card process, if I have employment verification letters with more detail in the job duties as compared to the ones submitted for H1B for the same employer, is it a problem? And the answer is no, as long as it is truthful and you're not completely doing a 180-degree turnaround and coming up with something totally different. As long as it is the same structure but more expanded, I don't see any problem with it. Okay. So I disagree with your lawyers if they ask you just get everything exactly the same as the H1B. Get everything that is truthful. Okay. And as long as it fits within the same parameters, there is no problem. All right. Now, folks, out of all the questions that I have read, anybody has any follow-up on any of the questions that I have read, no new questions, any follow-ups on the posted questions, press *5. After this, we'll start the new questions. *5 only on follow-up. I have one person who has a question. 3 people. Okay. 3 people who have questions. I will call upon you in the order that you logged into the conference. So let's start with California. California, go ahead, please.
Hi, Rajiv. This is Hari. I have posted the question number 6 related to filing the green card. My previous company I have 140 approved. My current company is filing for a green card. In case today's decision based on today's president's speech, let's say my priority date becomes current, can my previous company file for a green card by like filing 485 being with the current company without joining them?
The answer is yes, if the old company has the intention of hiring you back and you have the intention of joining them. After 180 days, you don't have to do either one of those things. You can stay with the same company if you have a similar job or any other company. But at least at the point of filing the 485, they should have the intention of hiring you and you to join them before or after approval of the green card.
Okay. Okay. Got it. Okay. Thank you.
You're welcome. Good luck. Okay, let's go on to the next person. And they are from Delaware. Delaware, go ahead, please.
Hi, Rajiv. I am asking for question number 21.
21.
For the visitor visa for my in-law.
Yes, yes, of course.
So actually, they are currently here and they would like to commence. I think my mother, she's going back to India on 30th and she would like to come back on March because, yeah, I'm expecting another baby. So still, it's create any issues. She will come back after 3-4 months. They are here only for 2.5 months actually.
Yeah, then it might be possible. If they had stayed the entire 6 months here, I'm sorry, I did not notice that. I thought they had been here 6 months. But if they've been here 2.5 months, chances are they will be allowed back in. Now, remember one thing. Sometimes when you say that parents are coming to help with a newborn child, USCIS and CBP can take the position, oh, that means you're going to work in the United States. You're going to become a nanny. Make it very clear that I'm coming as a grandparent to be around my grandchild, to provide moral support, to provide physical support if needed, but I'm not coming here to do a job. I'm coming here out of love and affection. Okay?
Okay.
So sometimes...
So that would be fine, right?
I think so. I mean, I can only guess because ultimate decision is in the hands of the CBP officer. But if this is a good reason, somebody has been here only 2.5 months, then they go back and they come back after 4 or 5 months to be around their child for delivery. I don't see any problem with that. I think there's a good chance that will go through fine.
Okay.
Okay.
Thank you.
Good luck.
Thanks.
Okay, and the last raised hand is from New York. New York, go ahead, please.
Hi, Rajiv. This is Tim. I have a question with regards to number 2.
Number 2. 1 second.
I'm sorry, number 12.
One second. 12. Let me get there. Give me 1 second.
Yeah, number 12.
Question
number 12. My name is Tim.
Let me get there, please.
I'm sorry, I can't hear you.
I said, let me get there. 1 second.
Okay.
So your question was, if I have children born in the United States and I'm on F1 or F2, does that help me, right?
Yes.
And
based on today's
right. And I said I doubt very much that President Obama is going to do anything for legal people in that particular situation. No, I don't think so.
Okay, but my one question was, since all the articles and everything that is talking about the parents of citizens, do you think my status would fit in somewhere there or no?
No, because...
or you don't know yet?
Well, we don't know yet, but my guess would be no, it will not. Because remember, what is the president going to do for undocumented people? He's not giving them any permanent status. All he's saying is, we won't deport you until we decide what to do with you or until the laws are passed. And we'll give you maybe work authorization. But that does not give them any permanent right to remain in the United States. So I don't think they're going to extend that to people who are legally here with US citizen children. And I don't think President Obama can even do that because that would be going beyond the limits of the statute. What he's going to do with undocumented people is an exercise of presidential discretion not to go after certain people. Okay. So it's a forbearance. It's a promise, so to speak, to not deport them, but it doesn't give them any rights. So I don't think you'll be covered by that. But who knows? I would like to be surprised, and I hope I'm wrong.
Okay, one more piece of information that I wanted to share with you. I was not on F1 for the whole time. I was on H and H4 both between this time, and I've been here in USA for 9 years.
I don't think
so. Does that help at all or no?
I don't think so.
You don't know, or you don't think so?
I don't think so. Nobody knows right now what he's going to say, but I don't think that's
Okay.
going to help you either. Okay.
Okay.
But let's
All
listen.
right. Thank you.
Let's listen to him tonight. Let's see what he says.
Okay.
All right.
Can I, call you again in this regard, or after
Basically,
tonight?
I mentioned this, and maybe you didn't hear that. What I said was, go to immigration.com, our website. On the top right, we have links to our mobile apps. They're all free. You can download the app, install it. And also my tweets are on the right hand side of the page, immigration.com. You can follow my tweets because I intend to be tweeting as well as sending people messages over the iPhone and Android phones about what the president is saying and what it means. Okay.
Okay.
So as he's
Thank
talking,
you.
I expect to be doing that tonight as he's talking. Okay.
Okay.
Good luck.
All right. Thank you.
You're welcome. All right, folks, we are done with all the posted questions. Anybody has any question, press *5 on your phone. Anyone has any question, new, old, go ahead, press *5. 3 people so far. 3 people with new questions. Okay, so let's deal with these 3 questions. Again, I'm going in the order in which these people logged in. So, Louisiana, go ahead, please, Louisiana.
Hi, Rajiv. Yeah, hi. This is Priya. I actually posted a question like last Thursday conference.
Okay.
So it was regarding my OPT card, and right now I am on F1 visa, F1 student visa, and my OPT card has been denied. I graduated like in May 2014, and my OPT was denied in August 1st. So my question is like I've done like motion to reopen on August 19th, and I called them and asked about the status. They said me that it will take like 4 to 6 months of processing for the motion to reopen. And I think purely just administrative error. But right now, I think that this system is like beyond repair.
Hang on one second.
Thinking of going back
Priya, 1 second. When you say administrative error, was it the DSO who made the error or USCIS made the error?
I think it's USCIS.
Look, if you Google USCIS space expedite, USCIS space expedite, you'll come to a page which tells you that they can expedite your case if they made the error, and it tells you how to expedite your case.
Yeah, I even tried that, and I got that thing, and I even tried that expedite thing, but that also didn't work. They say that I think they're accepting the mistake or so, but I'm not supposed to raise, finger on them. So right now not doing anything with that. So whatever they put in the denial notice that I have to do the motion to reopen, that's what I've done as per their suggestion. So, but they're saying like it is taking 4 to 6 months. But right now, I don't have any hopes from USCIS that they will be giving me like very soon or something. So my question is that now, if at all I go to India in like 1 or 2 months, and then while re-entering back, like if I get my OPT card when I'm in India and while re-entering to USA again, do I have any problem with that?
I think it's a very bad idea to travel while you have an MTR pending.
Oh, okay. Yeah, I mean, it's like kind of wastage of time.
I think it's a very bad idea. First, it could be considered to be an abandonment of the MTR if you leave the US. Second, unless the EAD is actually approved for you to travel, you may not be allowed entry back into the US. Okay, so I think it's a very bad idea to travel until the MTR is decided. Once the MTR is decided in your favor and you've got a job, it's okay to travel, but not before that.
Okay.
Okay.
Sorry, the last thing, what did you say? When the MTR is approved?
Once the MTR is approved and you've got a job, I think after that it's okay to travel. All right.
Okay. All right. Yeah. That's what my question was. I was just confused about it. Yeah. And right.
Priya, you're welcome to send me an email if there is anything that you need help with. I try to do whatever I
Oh,
can for every student. So just send me an email to help@immigration.com.
all right. Okay, no
Okay.
problem. Sure.
Good
Thank
luck
you,
to
Raj, so
you.
much.
You're welcome, ma'am. Bye bye.
Yeah, bye-bye.
Okay, let's go on to the next one. And this one is from the beautiful Florida. Go ahead, please, Florida.
Hi, Rajiv. This is Arvind. I have a question. Actually, my current employer tried to file for, but because of the layoff, that couldn't happen for 2 times. And now I have just 4 months left in my H1. So I explained with another employer, and that if an employer can take your case and like file for and possibly get the extension, we can probably go ahead with that. So I just wanted to know, is it possible to file a form and get the extension beyond 6 months, 6 years in 4 years, just 4 months?
No, Arvindji, it takes about 4 months just to set up a PERM application because getting, first of all, you have to prepare the application. Getting the prevailing wage itself takes about a month, couple of months of advertising. So it takes about 4 months just to set the thing up. So it's not going to happen in that much time.
Okay, okay,
Okay.
okay, okay.
Uh,
Thank you.
do you have any time to recapture? Were you outside USA at all?
Yeah, if I recapture, I'll get another maybe a month or so.
That doesn't help you much. But get your green card process started anyway. The earlier you start, the better off you are. And if by any chance your I-140 gets approved relatively quickly, then you could come back right away with your 3-year H1 extension. So start your green card process. There's advantage to it.
Okay,
All right.
thank you.
You're welcome.
Thank you.
Okay. And the last question for the day, folks, is from my neighborhood, Herndon, Virginia. Go ahead, please.
Hi, Rajiv Ji. I just had a quick question. So I got my green card through marrying my spouse. We've been married for 2 years. In July, filed for removal of conditions.
Yes, sir.
And things didn't really work out. So while I'm waiting for my permanent 10-year green card, we are filing for separation. Now my question is, what do I do at this point in time? Do I inform USCIS? What is my worst case scenario? Um, there are chances that I might be asked for an interview, and then she might not really come for an interview since we are separated. Or should I just wait it out because usually it takes about 5 to 6 months to get the green card. I'm already down with 4 months. It's a matter of a couple of months. So at this point in time, I'm really not sure what to do.
I don't know the answer to your questions. Unfortunately, I'll tell you what the problem is. The issues that I see, number one, am I obliged to inform USCIS if we have legally separated? And I always err on the side of caution. I always do it because I don't like to take chances with USCIS coming back and saying, you concealed information from us. We have a good defense because on the day you filed your paperwork, your marriage was undisturbed. That's the first issue.
Right.
Second issue is it's been a problematic issue when people are undergoing divorce, but the divorce is not final. The old process used to be you had to wait until they put you in deportation, then go before the immigration judge and prove that when you entered into the marriage, you entered into good faith, but it didn't work out. Because the law only requires that you enter into marriage in good faith. It doesn't require that you got to stay married. Sometimes things don't work out. So, what I want you to do, I want you to get yourself a lawyer, somebody who's competent, who can look up the current state of affairs for these two issues. Because somebody's going to have to hit the books on this. Are we obliged to inform them? And number two, what do I do about the fact that we are legally separated? Okay, because do I have to go through deportation and then make my case, or can we make our case? Because USCIS has issued a couple of memoranda on this a couple of years ago, and they settled this issue, but I don't remember off the top of my head what those memoranda said. So I would advise you, sir, to get yourself a lawyer. Okay.
Okay, so I've already sent an email to Suman at Immigration to set up,
Sure.
an appointment with you.
Okay.
I just wanted to see if there is, what are my chances, if there's an interview, even if if the interview does not come and I just get my green card, am I safe after that? Because we haven't really filed anything legally, and we're just living separate now, but we haven't really filed for separation. We haven't really gone through, a divorce lawyer or anything like that.
Let me think about it. When we do a consultation for you, I'll figure out what is the best way to proceed. Okay?
Okay.
Good luck.
All right, then I'll be reaching out to you.
Yeah, because you've already sent an email to Sumanji. She'll take care of it for us.
Okay, I've already done that. So
Very
looking
good.
forward to the reply.
Absolutely. We'll be happy to assist, and good luck to you.
Thank you.
You're welcome. And there's one more question that has come up, it looks like, and this is from California. California, go ahead, please. Last question of the day.
Hi, so Rajiv, this is a question about I'm working on H-1B and my I-140 is approved, and my marriage is pending to someone who is in India, who's an Indian citizen, but she's born in Nepal. Do you think the USCIS could deny my
Well, I'm not
petition?
going to repeat my answers because I've already answered this question in great detail. Okay, so you missed those answers because you were not logged in on time. Just listen to my answers. I have answered this question in great detail. Your case cannot be denied just because USCIS wants to, but it's going to be tricky. You've got to prove her date of her place of birth. So just listen to this. I'll have the recording up later tonight. Okay, I'm not going to repeat those answers.
Okay.
Good luck to you.
Oh, all right. Thank you.
You're welcome. And it looks like we have yet one more question. Back to Florida. Guys, please don't do it like this. Just raise your hands all at once so I know how many people are there. Okay, the last question of the day. Go ahead, please. Florida.
Yeah, hello, Rajiv. Yeah, I apologize for.
No, that's okay. That's all right.
Actually, my company filed for L1A petition for the functional manager role,
right.
But I actually don't have a manager title. But the lawyer said that you don't need the title, but they will ahead and file it, and we got the RFE, and then finally the petition was denied, and they sent the denial notice. So they didn't actually say that I need to have a manager role. But it was denied. So a company is planning to file it again. So I just wanted to ask you, for a functional manager, L1A, does the person need to have a manager title?
Well, that depends. First of all, functional managers are the toughest L1As to get approved. Okay? Because the reason is you have to demonstrate to the USCIS that the function that you're doing is inherently a managerial function. Not an easy case to prove. It can be done. We have done several of these cases successfully. And I can give you a couple of examples. One case was there was a Middle Eastern company with a US branch. They sent their buyer out to USA, and the buyer had nobody to supervise. She used to sit in her home with just her computer and her telephone and purchase things for the chain in Middle East. USCIS denied the case, saying that this is not a manager. And we were able to show that she did transactions exceeding $50 million a year. And she had complete discretion over what to buy, pretty much. So this is not an ordinary person. This is a person with huge responsibility and discretion. Case was won. So when we took the case, we filed it again, we won. Second example is in a recent case, we have a company, large company, 7,000 employees globally, and they're an IT consulting company, and one of their managers, whose responsibility was to set up the pricing. So what he did was he went from project to project, and he sat with the team and decided what the pricing for the consulting services was going to be for a particular project. Now, USCIS, when we filed the case, they are our clients. They've been our clients for a very long time. So when we filed the case, initially they objected. Then finally we were able to show that this is an individual who has a lot of discretion in what he is doing. And if you look at the hierarchy of the company, he's at par with other vice presidents. So even though he's supervising nobody and his job goes from project to project to project, he is still a managerial officer, and they gave him the managerial function L1A. Does the title matter? Yes. If your title is software engineer and you claim that you're an IT manager, that's not going to work for you. The title itself is not all, but title is indicative of what you do. Okay.
Okay.
Anything else?
And does it make any difference or make it easier if I take like blanket petition and try the same as the consular?
No difference in my opinion. I think you're going to have the same problem.
Oh.
Guys, I'm not going to do any additional question. I see another hand raised up. I'm sorry, I'm not going to be able to. I've got only 5 minutes left to this call. But go ahead, sir. Florida, go ahead. Florida.
No, I just wanted to like ask about the consular, and you already answered my question. So
Okay,
thank you so much for all you do for us.
My pleasure. I actually have about 5 minutes left, so I'll take the last question also. Go ahead, Connecticut. Go ahead with your question, please.
Hi, Rajiv. This is Kumar. I got my have an I-140 RFE, which is just a bona fide job. Okay, I'm in the 8th year of my H1. 8th year of my H1, and would like to know that what kind of a documentation that I need to submit for this bona fide job.
Oh man, that is like writing a book. I can't really tell you that. Basically, a bona fide job can come from 80 different angles. It's just not one angle. If you don't have a lawyer, please get yourself a lawyer. If you have a lawyer who doesn't know how to handle it, get yourself a better lawyer or more experienced lawyer. But this is not something I can tell you in a 3-minute conversation. So get yourself a lawyer. It's certainly something that can be handled as long as there's not something organically wrong with the way the company functions. I don't see any problem. Okay?
Okay.
Good luck.
Thank you.
You're welcome. Folks, as always, it is a pleasure and a privilege to talk with all of you. I'll be back with you in 2 weeks, next Thursday. And tonight, let's hope and pray that President Obama does something good for all of us as well. Thank you for being here. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.